Welcome back to the channel where I cover missing persons, unsolved cases, crime news, and more. Well, we finally got a decision after months of waiting. You remember you guys saw that I was posting when it was supposed to hit earlier in July, 14th, 15th, but they got it out the door at the skin of their teeth yesterday, July 30th. The New Mexico Supreme Court did put out their decision, and it's not in the best interest of the state. Um, in short, they sided with the district court, which means that body cam evidence, when she did her little confession that it just came out of me, and her mom is all about, Lexi, we've talked about this. All of that, they can't use it at her trial. That said, I think they still have a lot of evidence that they can use. Obviously, they've got witness testimony they can use. They can use the videos from inside of the hospital where she's, rushing herself to the bathroom, holding her butt, and of course, exiting the restroom, coming out, and then the poor cleaning lady who had to discover the horror of her dead baby in that trash can. So let's go through the Supreme Court decision together here. So here is the decision. Since I was on their list, I did get an email once it went live yesterday. Like I stated, um, they didn't respond to my emails, so I'm assuming I probably wasn't the only one when they did not come out and they claimed that they had closed that session out, and they were starting the new arguments pretty soon. So this was one of the cases that they didn't have out with their decision, and I was hoping, considering that we have waited this long, again, I was really hopeful that they would side with the state and let that body cam back in, but unfortunately, that's just not the case. So, as you can see, it's State versus Trevizo, Supreme Court of New Mexico, July 30th, 2026. And then there's the docket number S-1-SC-40478. And these are the decision makers. These are the Supreme Court justices that decided against using this body cam evidence. You say Michael Vigil, Julie Vargas, Shannon Bacon, David Thompson, and Brianna Zamora. And then, of course, here is the actual argument, well, their decision rather, excuse me. And the slip opinion is the first of an opinion released by the chief clerk of the Supreme Court. Once an opinion is selected for publication by the court, it's assigned a vendor neutral citation by the chief clerk for compliance with Rule 23-112, MNRA, authenticated and formally published. The slip opinion may contain deviations from the formal authenticated opinion. So I guess this is their initial opinion, and I guess it could change slightly, but I'm assuming nothing besides certain terms, but it's not going to change from they sided with the district court to not siding with the district court. So I'm not as familiar with the Supreme Court decisions as I am the regular court, but we all know, it's not in the favor of the state of New Mexico. And I honestly think the gentleman, and I am blanking on his name right now. I think it's probably on here. Yeah, that might have been his name. I think he's the Assistant Solicitor General, Michael Thomas. I think he may have been the one who argued it. I gotta say, I think he was super nervous. I don't know what you guys think. I put up the video when it happened. I think I put it up within a day or so. And check out my playlist for this case. But he did not seem to me, either he wasn't well prepared or he was way too nervous. I don't know, but I felt like they could have had a stronger person that presented this argument for the state. But let me know what you guys think as well. And again, this is State of New Mexico, which is the plaintiff appellant versus Alexee J. Trevizo, defendant appellee. Interlocutory appeal from the District Court of Eddy County, Jane Schuler Gray, District Judge. And there's the Raul Torres, Attorney General, Santa Fe, New Mexico. Michael J. Thomas, Assistant Solicitor General, Albuquerque, New Mexico, for appellate. And then we have Gary C. Mitchell, PC Gary C. Mitchell, Rudacio, New Mexico, or as I like to refer to him, Colonel Sanders. I'm curious if he's still up and ticking with you know his energy level, because I mean he's a smart guy. Remember, I went over his credentials in a video, but he's not getting any younger. So I'm curious if her representation will change. You know for the actual trial. And we also have a couple others here. So this could be some of the changes here. Law Office of Amber Freierberg. And then you have Pregnancy Justice. It looks like Coolisum, I Jazz, and Karen Thompson from New York for appellee. The Law Office of Ryan J. Villa, Catherine Lowe, Richelle Anderson, and Albuquerque, New Mexico. University of California, Irvine School of Law. Man, there's a lot going on from here. So anyway, Dodd Office, Law Office, LLC, Lawyers for Good Government, for Amicus Curiae, American College of Obstetricians and Gynecologists. So again, lots of names before you even get to the opinion. Okay, it says Vigil Justice. 1. This case requires us to clarify the contours of our physician-patient privilege set forth in Rule 11-504 NMRA and waiver of the privilege in light of the need to protect patient autonomy and access to care. For the reasons set forth herein, we conclude that the physician-patient privilege belonging to defendant Alexee Trevizo was not waived and affirm the order of the district court suppressing all evidence obtained by the state subject to the privilege. So that's, in short, that answers the question of they sided with the defense. 1. Background. A. Facts. 2. Defendant was a 19-year-old high school student on the occasion of the incidents leading to charges against her. On January 27, 2023, she went to the Artesia General Hospital Emergency Department, ED, in Artesia, New Mexico, with her mother around midnight seeking treatment for severe lower back pain. She told Dr. Heather M. Vasquez, the ED doctor, and nursing staff that her pain began after cheerleading practice earlier that afternoon. Asked if she was pregnant, defendant responded she was not, stating she had vaginal bleeding and that she was currently, quote, on her period, unquote. Yeah. 3. Triage began at 12:13 a.m. and defendant rated her back pain to be 10 out of 10, with 10 being the most severe. At 12:18 a.m., defendant was given ketorolac, a non-steroidal anti-inflammatory drug, acetaminophen, which we all know is a painkiller and fever reducer, onsteron, a drug to prevent vomiting, and cyclobenzaprine, a strong muscle relaxant. 10 minutes later, at 12:28 a.m., defendant's nurse administered intravenous fluids of sodium chloride with additional ketorolac, additional onsteron, an unknown additional amount of cyclobenzaprine, and an unknown amount of morphine. Morphine is a strong painkiller that induces sleep or drowsiness and is listed as a Schedule II drug on the Schedule of Controlled Substances Act. 4. At 12:28 a.m., Dr. Vasquez ordered a serum pregnancy test, a standard practice for someone of defendant's age with her symptoms. The serum was collected at 12:30 a.m., and the result showing defendant was pregnant was reported to Dr. Vasquez and defendant's nurse at 12:51 a.m. Notwithstanding the positive pregnancy test, defendant's nurse continued administering the IV medications to defendant. Defendant continuously received ketorolac, ondansetron, cyclobenzaprine, and morphine for 48 minutes from the time the pregnancy test result was reported to Dr. Vasquez and defendant's nurse until the IV was disconnected. The amount of medication administered is unknown. The IV was stopped at 1:39 a.m. when defendant told her nurse she urgently needed to have a bowel movement. The sensation of needing a bowel movement may have been an indication that defendant's cervix was fully dilated and she was moving into the delivery phase. Nevertheless, defendant was not informed by any hospital staff that she was pregnant. The nurse disconnected the IV to allow defendant to use the bathroom, and hospital security cameras footage shows defendant running down the hallway past the nursing station clutching her backside. Well, she was clutching her butt, but that is the one thing I do wonder. Why didn't, well, actually, two things here. Why didn't they inform her before she went to the bathroom that she was pregnant, which we all know she knew she was pregnant. Come on. But second of all, um, why did they let her go into that bathroom alone? But I will say, I can tell you, they did not think she would give birth in there and kill the baby. I mean, who would think that somebody would do that? I wouldn't. 5. Defendant was in the locked bathroom for 19 minutes. While defendant was in the bathroom, defendant's mother and nursing staff checked on defendant but did not enter the bathroom. From 1:53 to 1:56 a.m., Dr. Vasquez and nursing staff again checked on defendant without entering the bathroom, but they were ready to open and enter the bathroom with a key. Defendant gave birth to a newborn she described as not moving, crying, or breathing. 6. At 1:57 a.m., defendant exited the bathroom and walked back to her room with Dr. Vasquez. Minutes later, at 2:02 a.m., Dr. Vasquez ordered a transvaginal ultrasound for defendant because of her profuse vaginal bleeding. At 2:20 a.m., Dr. Vasquez performed a pelvic exam on defendant for the first time. Despite noting a significant amount of blood, multiple extremely large clots, and defendant's wide open cervix, Dr. Vasquez did not inform defendant of her dire emergency condition. 7. After being called to clean up blood from the bathroom and hallway, ED cleaning staff found the newborn in a trash can inside the bathroom at 2:27 a.m. Dr. Vasquez pronounced the newborn dead at 2:28 a.m. Autopsy lab results later showed that the deceased newborn had free morphine in his heart blood. 8. Realizing that defendant was not only vaginally bleeding but had just given birth and could die from a postpartum hemorrhage, Dr. Vasquez contacted Loveless Regional Medical Center, Loveless in Roswell, New Mexico, to arrange an urgent transfer. Dr. Vasquez did not re-examine defendant or discuss defendant's condition with her until law enforcement personnel were present as witnesses. 9. Law enforcement was notified immediately, and 2 police officers with the Artesia Police Department arrived at 2:38 a.m. The charge nurse was the first to speak to them and immediately told them defendant wouldn't tell us she was pregnant and killed the kid. Well, it's true. Dr. Vasquez joined the conversation and told the officers that she had not yet told defendant what was going on or about defendant's need for an urgent medical transfer. Dr. Vasquez told the officers the gravity of defendant's medical condition. So, officers, first thing, I need to make sure the mother is stable. I don't know if she delivered a placenta. She's bleeding a lot. She asked if one of them wanted to be a part of the conversation and invited the officers into the defendant's room. The officers both proceeded to defendant's room together with Dr. Vasquez and the charge nurse. See, I don't think that this nurse and the doctor were trying to do any kind of privacy violation, HIPAA violation, which obviously the Supreme Court disagrees with. But I think at this point she committed a crime, and she did. So that's what they were, concerned about. She gave birth in the bathroom and didn't tell anybody, and heck, this doctor cares about her well-being, and Alexee didn't even care about this baby's well-being that she just gave birth to in the bathroom. 10. Just after 2:41 a.m., the 2 uniformed armed male police officers, the male charge nurse, and Dr. Vasquez entered defendant's room. Defendant's mother was in the room as her designated caregiver and emergency contact. Dr. Vasquez positioned herself at defendant's bedside while the officers and the charge nurse blocked the doorway. Dr. Vasquez immediately confronted defendant with a statement, "We discovered a dead baby in the bathroom." And defendant responded, apparently not only to Dr. Vasquez but also to the police, "I'm sorry, it came out of me. I didn't know what to do." Defendant added that she held the baby and there was no movement, no breathing, nothing. One of the officers wrote in his report after making the statement, defendant was detained, that she was not free to leave, and that he stood at the doorway to ensure she could not leave. Defendant was officially detained within 3 minutes after police officers entered the room. 11. Following this confrontation, Dr. Vasquez, for the first time, told defendant that she had a medical emergency and asked defendant's mother for consent to be airlifted to the nearest regional hospital because defendant just had a baby and I don't know if defendant delivered the placenta. She's bleeding significantly. The officers remained in defendant's room even as defendant received another vaginal examination. Defendant was airlifted to Loveless almost 2 hours after Dr. Vasquez determined she could die from postpartum hemorrhage. B. Motion to suppress. 12. Defendant was charged with one count of first-degree murder, or in the alternative, intentional abuse of a child resulting in death, and one count of tampering with evidence. Defendant filed a motion in the district court, 1. To suppress all statements made to her medical providers on the basis that her physician-patient privilege under Rule 11504 was violated, and 2. To suppress all statements she made in the presence of the police officers on the basis that the statements were obtained in violation of Miranda versus Arizona, 384 U.S. 436, 1966. Following a hearing, the district court entered detailed findings of fact and conclusions of law in all respects, granted defendant's motion. 13. The district court concluded that 1. Defendant's statements to her healthcare providers are confidential and protected under the physician-patient privilege of Rule 11-504. 2. Defendant did not waive the privilege notwithstanding the presence of the police officers when she responded to Dr. Vasquez's statement that a dead baby was discovered in the bathroom. 3. Defendant did not waive the privilege notwithstanding her mother's presence. And 4. When Dr. Vasquez entered defendant's room and told defendant that a dead baby was discovered in the bathroom, defendant's right to receive Miranda warnings was violated. 14. In its analysis, the district court explained that the statement made by defendant's own doctor that a dead baby was discovered in the bathroom was made in a highly confrontational manner and by any reasonable interpretation is shocking, confrontational, and designed to elicit a response. Further, the district court explained by failing to advise defendant of her right to confidentiality under the physician-patient privilege, by failing to invoke the privilege on her behalf, and by entering defendant's room only when accompanied by the police, Dr. Vasquez acted as an agent of law enforcement, refusing or at least failing to give shocking information to her patient except in the presence of law enforcement, made Dr. Vasquez an agent of law enforcement. Furthermore, the district court found defendant was surrounded by law enforcement officers, defendant was not free to leave and was effectively in custody, and defendant was not given Miranda warnings. 15. The state appeals directly to this court. New Mexico Const Art VI, stating that appeals in cases imposing a sentence of life imprisonment shall be taken directly to this court. And that's referencing New Mexico SA 1978, authorizing an appeal to this court or our Court of Appeals by the state from a decision or order suppressing or excluding evidence. State versus Smallwood 2007, NMSC-005. It goes on. Observing the New Mexico Supreme Court has jurisdiction to her interlocutory appeals in situations where a defendant may possibly be sentenced to life imprisonment or death. 16. On appeal, the state argues 1. That defendant had no physician-patient privilege because there is an exception to the privilege for reports that doctors are required by law to make to law enforcement. 2. That any privilege was waived by the presence of the police officers and defendant's mother during defendant's communications with her doctor. And 3. That there were no Miranda violation. We reject the state's argument related to the physician-patient privilege because we hold that defendant's statements were privileged. It is unnecessary for us to address the Miranda question. 2. Discussion. 17. Our review of the law of privileges and waiver is de novo. Allen versus LeMaster, 2012, stating that a trial court's construction of the laws of privileges and waiver is a question of law subject to de novo review. See Paccio versus Hudson, 2018. stating that whether specific communications are privileged is a mixed question of fact and law subject to de novo review. 18. The district court ordered suppression of all evidence obtained by the state in violation of the physician patient privilege. The physician patient privilege is set forth in Rule 11 504B of our Rules of Evidence as follows. A patient has a privilege to refuse to disclose or prevent any other person from disclosing a confidential communication made for the purpose of diagnosis or treatment of the patient's physical, mental, or emotional condition, including drug addiction, between the patient and the patient's physician, psychotherapist, or state or nationally licensed mental health therapist. The physician patient privilege applies by its own terms to a confidential communication, which is defined as a communication made privately and not intended for further disclosure except to other persons in furtherance of the purpose of the communication. Rule 11 504A5B. The purpose of the privilege is to encourage a patient to make complete disclosures of their symptoms and conditions to a physician without fear of publication. State versus Roper, 1996. This is because accurate diagnosis and appropriate medical treatment depend on a patient's willingness to disclose embarrassing and even potentially incriminating information. State versus Lucero, 2023. Thus, the privilege applies to both civil and criminal cases. I see what they're saying here, but she wasn't even honest from the get-go. So, of course, that's all null and void at this point. But 19. Of course, the physician patient privilege is not absolute. State versus Gonzalez, 1996. Physicians are subject to statutory reporting obligations under MSSA 1978, Section 32A 4 3A, 2021, amended 2025. And the patient can themselves waive the privilege. Rule 11 511 NMRA, stating the holder of a privilege may waive the privilege. Here, the state argues that the privilege is not attached because of the reporting requirements of Section 32A 4 3A, 2021, or that the defendant waived the privilege by discussing her medical condition with Dr. Vasquez in the presence of the two police officers and in the presence of her mother. 20. As a preliminary matter, the state does not meaningfully dispute that the defendant presented herself to the emergency room as a patient seeking a diagnosis and treatment from Dr. Vasquez and the ED staff for severe lower back pain, and those facts support a finding that their communications advancing defendant's care fall within the privilege. Instead, the state's arguments focus on the effect of Section 32A 4 3A 2021, and whether the defendant waived her physician patient privilege when she responded to Dr. Vasquez's question in the presence of third parties. We address the state's arguments in turn. A. Section 32A 4 3A 2021 and the physician patient privilege. 21. The state contends defendant has no physician patient privilege as a matter of law. Specifically, the state argues that the mandatory reporting requirement of Section 32A 4 3A 2021, combined with the mandatory reporting exception for the privilege under Rule 11 504D4, demonstrate that there was no privilege here. 22. The state's argument requires us to construe a statute and a court rule. We review issues of statutory interpretation de novo. Our primary goal when interpreting statutes is to further legislative intent. Although the first guide to statutory interpretation is the actual wording of the statute, we have recognized that where the meaning of the facial language of a statute is in doubt, the plain language approach may not lead to a correct interpretation of true legislative intent. State versus Strauch, 2015. Internal quotation marks and citations omitted. Further, in interpreting statutory language as well as much of the other work courts are called on to perform, it is necessary to think thoughts and not words. We have repeatedly cautioned that despite the belittling simplicity of parsing the words on the face of the statute, we must take care to avoid adoption of a construction that would render the statute's application absurd or unreasonable or lead to injustice or contradiction. Internal quotation marks omitted. Let's see. We therefore must examine the plain language of the statute as well as the context in which it was promulgated, including the history of the statute and object and the object and purpose of the legislator sought to accomplish. In addition, this case requires us to interpret a provision of the New Mexico Rules of Evidence, a question of law we also reviewed de novo. When construing our procedural rules, we use the same rules of construction applicable to the interpretation of statutes. We begin by examining the plain language of the rule as well as the context in which it was promulgated, including the history of the rule and object and purpose. And that's referencing Kimnis versus Dubisky, 2017. 23. Our analysis commences with the mandatory reporting requirement of Section 32A 4 3A 2021. Under the facts of this case, the plain meaning of the statute requires that every licensed physician who knows or has a reasonable suspicion that a child is an absurd or neglected child shall report the matter immediately to a local law enforcement agency. Emphasis added. Upon the law enforcement agency's receipt of the report, the statute orders that the law enforcement agencies shall take immediate steps to ensure prompt investigation of the report. Section 32A 4 3C, 2021. 24. The state then refers us to Rule 11 504, which sets forth the physician patient privilege. Subsections A, B, and C of Rule 11 504 provide definitions, describe the scope of the physician patient privilege, and state who may claim the privilege. Subsection D of Rule 11 504 in turn is entitled Exceptions, and subsection D4 in pertinent part states no privilege shall apply for confidential communications concerning any material that a physician is required by law to report to a public employee or public agency. Emphasis added. Summarize the state's argument is that the discovery of the deceased infant triggered a statutory duty for Dr. Vasquez to report the death to law enforcement under Section 32A 4 3A 2021, and therefore is no physician patient privilege under Rule 11 504D4. For the reasons which follow, we reject the state's argument because it's too broad. And that's what I think that the doctor thought, that it was in that realm that she needed to get law enforcement involved. So I think she did it. She thought that she was being, she wasn't breaking any kind of privacy, physician patient privacy or HIPAA. She was doing what she was supposed to do by the law. 25. The district court ruled the hospital had an obligation to notify law enforcement that a crime must have occurred, but is not entitled to abrogate the physician patient privilege. As we now explain, we agree with the district court. We construe the statute and rule together so they operate harmoniously. A patient may prevent disclosure of private communications with a physician made for the purpose of diagnosis or treatment of the patient's condition. Rule 11 504B, but no privilege applies to communications concerning any material the physician is required by law to report. Rule 11 504D4. Section 32A 4 3A 2021 identifies the matter which a physician must report to law enforcement as knowledge or a reasonable suspicion that a child is abused or neglected. Read together, the statute and rule do not create a blanket exception to the physician patient privilege. Rather, the exception is narrow. The unprotected material under Rule 11 504D4 is limited to the matter the physician is required to report, knowledge or reasonable suspicion of child abuse or neglect. And that's going back to Stotch 2015. What the Ohio reporting statute requires is actually quite minimal. When mandated reporters encounter suspected abuse or neglect, they must report it. Quoting State versus Clark, 2013. Let's see. The purpose of the reporting requirement is to cause a law enforcement investigation to be initiated. Once the report is made, the physician's duty ends and the law enforcement duty to investigate immediately begins. Outside this narrow exception to report, all confidential communications between the patient and physician remain privileged. They are not all automatically converted into unprivileged communications. See People versus Covington, Colorado 2021. stating that Colorado's mandatory reporting statute waived the physician-patient privilege only for the physician's observations of bullet injuries themselves and not for statements made by the patient to the physician. 26. Accordingly, we hold that once law enforcement was notified that a deceased infant had been found in the bathroom trash can, Dr. Vasquez and the hospital personnel satisfied their statutory reporting duty. Beyond these facts, defendant's physician patient privilege remained intact unless otherwise waived. We therefore turn to the state's remaining waiver arguments. So, calling the police was fine. That's what they're basically saying, it sounds to me like. Calling the police was fine to report that that a baby was found in the hospital trash can and died. Okay. And telling them that they suspected that it was her baby, which we all know it is because they could do DNA and all that. And obviously, but by bringing the cops into that room when she was speaking to them, that's obviously where this all gets problematic by the Supreme Court interpretation. B. Waiver of the physician-patient privilege. 27. Whether defendant voluntarily waived her physician-patient privilege by speaking to Dr. Vasquez in the presence of the police officers and her mother presents an issue we reviewed de novo, Allen 2012, stating that a trial court's construction of the law of privileges and waiver are questions of law subject to de novo review. The state's argument urges us to adopt a per se rule that whenever a third person is present who is not necessary for care or treatment while a patient communicates with their doctor, a waiver of confidentiality takes place, regardless of who the person is or of the circumstances. We reject that argument as inconsistent with case law and the policy interest underlying the physician patient privilege. 28. Rule 11 511 provides for the waiver of the physician patient privilege as follows. A person who possesses a privilege against the disclosure of a confidential matter or communication waives the privilege if the person voluntarily discloses or consents to disclosure of any significant part of the matter or communication. Fundamental to waiver under Rule 11 511 is the principle that the waiver must be voluntary. 29. Accordingly, our courts have required a finding that an alleged waiver was voluntary in order to be valid. See Lucero 2023. Our Court of Appeals in Lucero grapple with the same question before us in this case. Under what circumstances does the presence of a third party able to overhear a communication between a physician and a patient negate the privilege? The Lucero Court emphasized that any analysis of the physician-patient privilege must be anchored in the interests served by the privilege, protecting a patient's privacy and autonomy in relating highly sensitive personal matters concerning their physical or mental condition to a medical provider for purposes of diagnosis or treatment. Through the lens of a patient autonomy, Lucero seems to conclude that mere awareness that a third party is present is insufficient on its own to waive the privilege. Rather, Lucero also requires a showing of conduct sufficient to constitute voluntarily consent or acquiescence in the disclosure of their communications. Although Lucero does not reference Rule 11 511, the opinion nonetheless imposes the voluntariness requirement articulated in the rule. 30. In Lucero, the defendant was injured in a single vehicle rollover crash. The defendant was being treated in an ambulance when a police officer entered the ambulance and overheard the defendant tell an emergency medical technician, EMT, that she had consumed alcohol. When the defendant was later charged with driving under the influence of intoxicating liquor or drugs, she contended that Rule 11 504 prohibited a police officer from testifying to the statements made to the EMT and filed a motion to suppress the statements. Lucero 2023. At the evidentiary hearing, the trial court focused on whether the defendant knew the police officer was in the ambulance when she made the disclosure to the EMT. The trial court determined that the defendant should have known the police officer was present and therefore denied the motion to suppress. However, the Court of Appeals reversed the trial court and remanded the case to trial court for factual determinations, whether the defendant actually knew the police officer was present in the ambulance when she made her statement to the EMT, and if she did, whether her subsequent conduct was sufficient to demonstrate that she voluntarily consented to or acquiesced the disclosure of her statement to the police officer. 31. In support of the requirement of voluntary conduct, Lucero relied upon in re-termination of parental rights of Sherry C. and John M. 1991 for the proposition of a patient who has actual knowledge that the communications will be disclosed and voluntarily participates in the communication with that knowledge has consented to or acquiesced to disclosure of their physician-patient communication. Lucero 2023. In Re Sherry C, adds yet another layer to voluntariness under Rule 11.511 that was not explored in Lucero, but is implied in the discussion of voluntary consent, whether the patient had capacity to waive the privilege. In Re Sherry C, 1991, there was the Court of Appeals. The Court of Appeals. Whether the patient had capacity to waive the privilege in Re Sherry C, 1991. The Court of Appeals was reluctant to find that the disclosure was voluntary despite apparent actual knowledge or consent on behalf of the mother or her attorneys that the treating psychiatrists were reporting to the courts. Although the case did not ultimately turn on incapacity, it nonetheless carries the basic principle that capacity is required for voluntary waiver under Rule 11.511. 32. Based on the foregoing principles, we conclude that for a valid waiver of the physician-patient privilege to occur by the presence of a third party, at least the following requirements must be satisfied. 1. The patient must have actual knowledge of the presence of a third party, not essential to the care. 2. The patient must have the mental and physical capacity to waive the privilege. And 3. Under the totality of the circumstances, the waiver must be voluntary. Applying this test to the facts before us, we conclude the defendant did not voluntarily waive her physician-patient privilege. 33. Here there is no question defendant knew of the presence of both the officers and her mother, so we focus on the second and third factors of this analysis. The facts are disturbing in many respects. Defendant was a 19-year-old high school student who went to the emergency room around midnight because she was suffering from severe back pain, which she rated at 10 out of 10, with 10 being the most severe. Asked if she was pregnant, she said she was not, adding that she was bleeding and on her period. Within 5 minutes after being admitted to the emergency room, defendant was given pain medications and a powerful muscle relaxant, followed 10 minutes later by the IV fluids, adding more of the same pain medication and muscle relaxant, with morphine added to the mix. A pregnancy test was ordered, and 21 minutes later, the result that defendant was pregnant was reported to Dr. Vasquez and defendant's nurse. For unexplained reasons, defendant was never told that, notwithstanding her vaginal bleeding, she was pregnant. 34. The only medical response to the positive pregnancy test and knowledge that the defendant was bleeding was to continue giving defendant the IV fluids containing the powerful muscle relaxant and morphine. The IV was later disconnected only because defendant said she urgently had to have a bowel movement, a possible indication that defendant's cervix was fully dilated and she was moving into the delivery phase. Defendant was in the locked bathroom for 19 minutes and she gave birth to an infant she reported as not moving, crying, or breathing. She placed the infant inside a trash can in the bathroom and returned to her bed. Yeah, because that's normal, right? 35. 5 minutes after she returned to her bed, defendant's profuse vaginal bleeding prompted Dr. Vasquez to order a transvaginal ultrasound. Dr. Vasquez then performed a pelvic exam, finding a significant amount of blood, multiple extremely large clots in defendant's wide open cervix. Dr. Vasquez did not inform defendant of these serious, significant findings or advise her of her positive pregnancy test. When the deceased infant was discovered after the pelvic exam, Dr. Vasquez recognized that defendant could die from a postpartum hemorrhage. However, Dr. Vasquez decided she was not going to discuss defendant's life-threatening condition with her at that time. Her reason was that she wanted to wait for law enforcement presence as witnesses. 36. When the two officers arrived, the charge nurse told them defendant wouldn't tell us she was pregnant and killed the kid. Dr. Vasquez joined the conversation, telling the officer she had not yet told defendant what was going on or that defendant needed an urgent medical transfer. Dr. Vasquez told the officers, So first thing, I need to make sure the mother is stable. I don't know if she delivered a placenta. She's bleeding a lot. Incredibly, Dr. Vasquez asked if one of them wanted to be a part of the conversation with defendant and invited the officers into defendant's room. Police presence in defendant's room at that time was not required for any reason, medical or otherwise. The officers accepted Dr. Vasquez's invitation. Yeah, this is where the problem is. They went into this room. This is exactly it. But like I said, there's still plenty of evidence. 37. It was just after 2:41 a.m. when the two uniformed armed police officers entered defendant's room with Dr. Vasquez and the charge nurse. The police officers and charge nurse blocked the doorway while Dr. Vasquez went to the defendant's bedside and immediately confronted the defendant with the statement, "We discovered a dead baby in the bathroom." Defendant answered, "I'm sorry, it came out of me. I didn't know what to do." 38. We now proceed to determine whether the second and third requirements for a waiver of physician patient privilege was satisfied. 39. We first consider whether the defendant had a mental and physical capacity to waive the privilege. In this instance, there is a serious question whether the defendant had the mental and physical capacity to waive the privilege. She was experiencing excruciating back pain. Shortly after midnight, she received powerful pain medication, a muscle relaxant, and morphine. Even after medical staff learned defendant was pregnant, they continued those medications and stopped only when she said she urgently needed a bowel movement. Although the amount of morphine she received is unknown, it was sufficient to cross the placental barrier. The autopsy showed morphine in the infant's heart blood. Defendant also lost a significant amount of blood, expelled multiple large clots, and had a wide open cervix. Dr. Vasquez concluded that she could die from a postpartum hemorrhage. Under all the circumstances, giving birth alone in the locked bathroom was surely shocking, frightening, and stressful to the defendant. This was defendant's condition when the defendant's doctor, the charge nurse, and two armed uniformed police officers confronted her at 2:41 a.m. We would ordinarily remand for an evidentiary hearing on this question of capacity to waive. See Lucero 2023. However, we do not do so here because the facts unequivocally demonstrate that due to defendant's medical condition, she lacked capacity to waive her physician patient privilege. Yeah, I don't agree, but the Supreme Court has ruled. 40. And given the absence of capacity to waive and the circumstances surrounding her disclosure, the third prong of the test also supports defendant's claim that her physician patient privilege remains intact. Indeed, the totality of the circumstances indicate that any waiver by defendant was not voluntary. In the hours before, defendant presented at the emergency room in excruciating pain, was administered numerous medications, including narcotics, at unknown doses. She gave birth and she suffered ongoing life threatening blood loss. Despite her unresolved medical crisis, Dr. Vasquez, without authorization, ambushed defendant, bringing with her two armed officers who stood in the doorway of her hospital room and disclosed her personal medical information to all persons in the room without warning. Defendant was not given the opportunity to exclude anyone from the room before Dr. Vasquez discussed her condition in the presence of others. Considering this sudden unauthorized disclosure, coupled with defendant's compromised medical condition, under the totality of the circumstances, we cannot conclude that defendant's waiver of her physician patient privilege was voluntary. 3. Conclusion. 41. We affirm the order of the district court suppressing all evidence obtained by the state in violation of her physician patient privilege. 42. It is so ordered. So there you go. And there's all the footnotes here. I'll include a link to this in the information of the video in case anyone wants to look at it. I'm very disappointed with the Supreme Court's decision. As much as obviously I'm not a legal expert, as most of you guys aren't either, the more I read these documents on in these cases, I do tend to understand a little bit more. It's so I can see where they're coming from. They have to go by previous cases. They all set a precedent and all that sort of stuff. I think again that the Dr. Vasquez was doing what she thought was the right thing to do. And it sounds to me like the Supreme Court is stating here that it was fine that she called the police to be there, but having them in the room while she disclosed all this to her is really the biggest problem. So that is why, well, among other things, but this is the main reason why that the physician patient privilege was encroached upon, because they're saying, oh, she was drugged up, she wasn't told all this, you know yada yada yada. So if the cops just were to be outside the room and not there when she was talking to them, I guess any of that body cam could have been used. But it looks like it's now going to be no longer able to be used, and that's that. I am curious how fast, and I'm hoping fast, that the state of New Mexico will get a trial going, because really, 3 years. I mean, they got to get this girl tried, and I personally think that there's still enough evidence to support her guilt. Um, they can go on and say all these things. She could say the baby wasn't breathing, but the autopsy says otherwise, that the baby did draw a breath. So there's a lot of other evidence. There's the witnesses, obviously, those witness statements from the hospital staff, that poor um, cleaning lady who discovered the baby in the bathroom trash can. And of course, Alexi's got former classmates, and I'm sure there's text messages that she knew she was pregnant. And heck, look at those photos of her in her cheerleading outfit while she was pregnant. You can't tell me she just thought she was bloated and fat from eating McDonald's and Burger King. No. And that's, of course, what, you know, attorney Colonel Sanders was trying to say. Oh, she just ate out a lot. Yeah, I don't think so, dude. I mean, look at her. Like, not long after she went to prom. I mean, I know that disgusted me to no possible end. So I'm still hoping and praying for justice for this sweet baby. Because there's just her family, like her mother, and it doesn't even seem like, her boyfriend and her, who's the daddy that we assume, uh, and his mother seemed too concerned about this entire situation. But the lack of care on Lexi's part and her mom's part, it's just appalling. The only one, if you guys remember seeing the body cam in the emergency waiting room, is her stepfather. He looks shocked, and like he's the only one to me that had any sort of real response from the family of, damn, this is not right. Mom, on the other hand, she's more upset that Lexi might go to jail. I mean, she was upset when they came to the house and took her to jail. Boo-hoo to her. But this is a girl, again, who we see all these time with these girls and others, but they just don't have, I don't know. I mean, they're just not taking responsibility for their actions. And I believe that mom knew. I think she knew that Lexi was pregnant. I do. I think she knew. And her statement, which is no longer admissible at the trial, that Lexi, we've talked about this. Well, gee, mom, why did you talk about this before? Why? Hmm. All right, guys, I know this is a long one because we went through the Supreme Court decision, but please let me know your thoughts in the comments, and hopefully there'll be some more movement soon on this case continuing to hit a jury trial. But with that said, I hope you have a great rest of the day, and most of all, stay safe.